Welcome back. Thank you very much for staying with us. Now, the City of Johannesburg says the warrant of arrest issued for City Manager Floyd Brink was found to be defective and inaccurate and as a result could not be legally executed. This follows a visit this morning to Brink's Roodepoort home west of Johannesburg by the sheriff of the court. This was in an attempt to enforce a warrant of arrest on Brink in relation to a matter that involves a resident of the city as well as a disputed utilities account. The Johannesburg Mayor spokesperson Mlimandlela Ndamase joins us live now on this particular matter. Mr. Ndamase, good afternoon and thank you very much for your time. This story is quite multi-layered. So the city manager was almost arrested today and we understand he was saved by a mere spelling error on his surname. Talk us through the matter that brought us to this point where the Joburg city manager was almost cuffed today.
No, thank you very much and good afternoon to your viewers. Yes, there was some attempt, which we have labeled as very mischievous, by the sheriff of the court together with the legal representative of the litigant in this particular matter to execute what they termed as a warrant of arrest on the city manager this morning. For background, this relates to a litigation that was brought about by a client of the city in relation to their utilities bill, and the city was therefore ordered by the court to not take any punitive steps such as disconnection whilst the litigant and the city are engaged in discussions and in negotiations with regards to that particular bill that is due and to be settled by the client. Unfortunately, the client yesterday experienced some disruption in their services and they allege that these services were disconnected by the city, and as a result they sought to then execute a warrant of arrest on the city manager for contempt of court in that the city did not respect the court order that is currently in place interdicting any disconnection of services to that particular client. But what has been mischievous and interesting to us is that, as you would know, in this country it is the South African police services who carry the legal authority to effect an arrest on the basis of a warrant of arrest. Secondly, this particular warrant, the sheriff and the legal representatives of the client of the city sought to serve it at the private residence of Mr. Brink, not at the official address, which is the address of his office as city manager, and in which capacity he was cited in the papers of this particular action. And again, it is the sheriff and the legal representatives of the client who then alerted and took videos outside of the house of Mr. Brink, violating OP Act and a number of other pieces of legislation, and including his right to his privacy, so that there could be some media sensation and attention and emotions drawn to this particular issue. So we are not naive. We have noted these actions, and given the politics that obtain in the city currently and the consistent harassment that we have seen against Mr. Brink as a city manager, we do view this in a serious light and associated with those particular political interests.
Mr. Ndamase, I want us to park the politics for a second and talk about the very important fact that you actually state that there was a disruption to the water supply of this particular gentleman. Do you know what was the reason? Because if there was an order not to action anything pending the finalization of that matter, then it would mean that the city acted against an order. Have you established what that disruption was for?
From what we have established at this stage in our preliminary investigation is that the client was not scheduled for disconnection on our side as a city, based on the fact that we know that there is an interdict and that particular account is flagged on our system. The investigation that the technicians who went on site today have since reported is that they also believe that there is no disconnection that was effected and are trying to establish what the basis of the disruption of services was. And again, you would recall and would perhaps know that when the city disconnects your services, it does leave a notice signed by the technician deployed on site stating the reason for the disconnection, so that you as a client may then be informed that your services have been disconnected. In this particular instance, such was not present. So it tells us that there is a disruption as alleged by the client. However, that disruption was not as a result of the city having actively disconnected the client.
All right, so you can confirm that indeed there was a disruption. Was it just at his home or perhaps the whole street?
Well, one would have to get the details, but at this particular point, of interest to us was this particular client and their particular property.
So then if you say indeed you have established that there was a disruption, it means he was well within his rights to then seek an order or to actually go and challenge that now the city is in contempt. Even though you say that it wasn't on your part, but you would say that legitimately he could attempt to have the city held in contempt.
Well, disruptions are caused by a number of things. In some instances, you may have an aerial disruption, you may have a disruption based on vandalism or theft of infrastructure. But in this particular instance, you must remember the city was interdicted from actively going out and disconnecting this particular client. And it is the city's case at this particular point, based on the investigations done today, that the client was not disconnected by the city, and therefore the rights that are contained in the order and the interdict would not be applicable because the city has not taken any active action to disconnect the client.
Now, we understand that the city has directed its legal team to file an urgent application with the court to postpone the execution of that warrant. Just talk to us about this.
Yes, the city has had to take that action so that it can be able to protect the rights of the city manager, firstly. But secondly, as the details and the facts emerge, it is clear that the city did not disconnect the client, and therefore the execution of that particular warrant of arrest would be premature and unnecessary in this regard. But also, again, as I've stated, we are also of a strong view that we must be concerned with the manner in which this particular attempt to arrest the city manager, so-called, was executed by the sheriff and the lawyers of the applicant.
Mlimandlela, thank you very much for your time this afternoon. That was Mlimandlela Ndamase, Johannesburg Mayor spokesperson.